welcome everybody to the discussion tonight on Bill C-31 on the right to refuge. My name is Am Johal. I work here at the SFU Woodward's Cultural Unit, and as part of SFU's Vancity Office of Community Engagement, we're happy to be partnering with UBC's Lew Institute for Global Issues and the Tyee to bring this discussion. Once again, we have about 120 seats we're allowed to have in here because of fire limit rules, and so apologize if some of you don't have seating, but there are some chairs available up front. Also wanted to begin by acknowledging that we're on unceded Coast Salish territory, and really glad that we have such a great turnout for this very important discussion. Though we have the partners, this discussion couldn't have happened without the tireless energy of the person I'm about to introduce you to, but I ask you to give a warm welcome for Shayna Plout.
Hi everyone. I'm going to do something that I know I'm terrible at doing, which is actually read from prepared notes. But first of all, I have to say I'm pretty floored by the turnout, and I'm so glad that everyone was able to come and that everyone wanted to come. I wanted to say thank you to SFU Woodward's Cultural Unit, the Lew Institute for Global Issues, and the Tyee for sponsoring this event. The right to seek refuge in Canada, implications of Bill C-31. Thank you also to the panelists, Sherilyn, Elizabeth, Lobot, and Harsha, who will be joining us very shortly. There was an emergency, but she is coming. And our keynote speaker, Lesley, and our moderator, Peter, for volunteering to share their time, experience, and expertise in this public forum. Am deserves a special thank you as he agreed to take this on and host this event at very short notice. This is truly being done out of a labor of love. You will notice tonight that we are using a lot of law in our discussion, both Canadian law and international human rights law. But it's very important to remember that the land we are on was and continues to be the territory of the Musqueam, Squamish, and Tsleil-Waututh nations. This land has been shared between the three nations for thousands of years. Their law and protocols on being a guest and a host are much older and must be acknowledged. Now, I know no one came here to hear me, but I wanted to contextualize this conversation and the impetus behind this event. So although I'm not known for brevity, I'm going to give it a shot. And please kick me off this podium if I go more than 5 minutes, okay? Timekeeper? All right, there we go. I am the granddaughter of refugees. I have worked with refugees and torture survivors and irregular migrants, particularly the ROMA, for over 15 years in 7 countries. In February, when Bill C-31 was introduced, I was in London, England, not Ontario. One day I started to receive alarming emails from both Roma in Canada and members of the queer communities. Now, it's rare for Roma and LGBTQ populations who are seemingly so different to be talking about and organizing around the same thing. And given history, it's not usually a good sign. So I started to pay attention. As I dug deeper, I saw frightening provisions in proposed Bill C-31. Some of which have already failed in other countries. There's a provision to detain all refugee claimants by boat, a practice pioneered in Australia, but one which has, and I quote here, had no deterrent effect. Another one allows the Canadian government, without expert review, to create a list of so-called safe countries. What this means is that if the government says it's safe, like Hungary and Mexico, which is where most of the refugees from Canada are coming from, then you are immediately viewed with suspicion. Since your country has been deemed safe, how could you have refugees who want to leave it? Right now, Bill C-31 grants a refugee who is from a so-called safe country only an extremely limited 15 days to make a claim. 15 days. Try getting anything from the Canadian Post overseas in 15 days. You at least have 30 days to try and get change over your driver's license when you come here to be safe. Now, everyone who is familiar with this refugee process, lawyers, doctors, religious institutions, psychologists, and refugees themselves. Everyone agrees that this is impossible. There's more. Selective denial of permanent residency status, anemic appeals processes, etc. Our esteemed invited guests will explore all of these things. But for me personally, one of the most troubling things is the government's rhetoric and language surrounding the proposed changes. Terms such as bogus refugees are specifically created to set up a dichotomy, a harsh binary of us versus them. And this is dangerous. But why this event? Why not just work with lawyers and write letters? The whole reason that I was in London while receiving emails about Bill C-31 was that I was conducting research with migrants in the UK who were trying to respond to the rapid xenophobia that has become both endemic and institutionalized, with some arguing that it's endemic because it's been institutionalized. Xenophobia that has stripped refugee applicants to the right to education, to work, the right to family life, and at times subjected them to physical violence in the busy streets of London and the normally quiet countryside. I met a refugee who was a doctor in his home country, who, as a refugee claimant, was not permitted the right to work in the UK, denied the basic dignity of supporting himself, and resorted to eating out of trash cans. I met another refugee claimant who was detained for over 3 years until he organized a hunger strike, which finally brought in the attention of a journalist, and then a lawyer, and then a judicial review of the process. Masked forced detention is now no longer the practice in the UK, although this is one of the new regulations being considered here in Canada. You see, we have seen what happens when the law becomes used to criminalize refugees. And we have seen where it leads, what it teaches the larger society: fear, suspicion. It was in this context of fear and suspicion in the UK that I received information about Bill C-31, that I recognized that the problem was not just one that affects refugees. It speaks to and about us, those who are already safe in a safe country, and have the power to grant that safety to others who need it. The event tonight is necessary because this is not a niche issue. You look around you and you can see that. The treatment of refugees, of people who are fleeing their home countries based on a well-founded fear of persecution, as it is defined, is an issue that speaks to and for and about us, people who act as guardians and gatekeepers of this safe land. How do we respond to those seeking refuge? What are their rights? What are their responsibilities? What are our responsibilities? What larger picture is Bill C-31 speaking to and responding to? And why does it feel like there is an intentional and strategic shift to fear those who are fleeing from fear? These are just some of the issues that we'll be exploring tonight with our speakers and with the skilled facilitation of our moderator, two-time Emmy Award winner Peter Klein, who has over 20 years of journalism experience. He is the director of the Graduate School of Journalism at UBC and the founder of the International Reporting Program. Peter also has a personal connection to this issue. His parents fled from persecution from Hungary after the revolution. They found safety as claimants here in North America. Hungary is now one of the top source countries for refugee claimants in Canada, and one of the countries that will most likely be deemed safe. Of course, one of the many questions this raises: how can a country be safe if you're fleeing for your safety? I thank you for coming out this evening to engage and to learn and to do. Peter, I turn it over to you.
Thank you, Shayna. That was very moving. I'll run through very quickly the format for tonight, and then I'll turn it over to our speakers. We're going to hear from very respected immigration lawyer in a moment and as a keynote, and afterwards we'll hear from each of the panelists for about 5 to 7 minutes, and following that we'll take questions from the audience, my favorite part and the most interesting part of the evening. But let me first introduce Lesley Stalker. Lesley Stalker first met her refugee client at the student clinic at the law school that she stumbled into. 2.5 decades later, she continues to be impassioned by refugee law and, more importantly, the people whom it serves. Lesley worked as an immigration and refugee lawyer for close to 18 years. In the course of this work, she became aware of the special challenges faced by claimants who had been tortured, traumatized, and she served on the board of the Vancouver Association of Survivors of Torture, VAST, for 10 years. She chaired the refugee lawyers group in Vancouver for 2 years before accepting a position as regional legal officer with the UN High Commissioner for Refugees for Western Canada in October 2007. Her household includes, in no particular order of importance, 2 children, 1 guinea pig, a scarecrow, and a scarecrow in the front lawn. She never tires of hearing the stories of refugees and is continually awed by their resilience and their determination. I'm very pleased to introduce Lesley Stalker.
I wish people would lose adjectives. How can I possibly live up to the adjectives that Peter has used? I am going to try and use PowerPoint, which means that I'm going to try and talk and use my hands at the same time. Please forgive any stumbles. I've chosen this picture on the opening slide because it's actually one that's on CIC's website. CIC is Citizenship and Immigration Canada. They are the people who are behind Bill C-31, the legislation that we've gathered to talk about tonight. This picture is part of their tribute to our history of refugee protection. Shana had asked me to speak a little bit about the background to refugee protection and the definition that we use. So I'm going to spend a few minutes going over the historical background to the system that has been introduced and used in Canada and around the world. So sometimes the 20th century has been referred to as the century of refugees, century of displacement. And we can look back to 1914, and of course there was a great and bloody war. And when the war was over, the international community said, never again. And they created the League of Nations. The covenant of the League was very clear. Nations were to work cooperatively for international peace and security. Their conduct was to be governed by international law rather than self-interest. The articulation of legal principles can be difficult, but implementing them can be equally challenging. And one of the urgent tasks that faced the League was to find a solution to the massive displacement created by the war, by the Russian Revolution, and also by the breakdown of the old ancien regimes like the Ottoman Empire. This was a really unstable situation which needed to be addressed by the League for humanitarian as well as political reasons. So in 1921, the League of Nations appointed quite an extraordinary man by the name of Fridtjof Nansen as the first High Commissioner for Refugees. He was quite a remarkable man. He was a renowned biologist, oceanographer, Arctic explorer, a phenomenal skier, and also a well-respected statesman. But neither Dr. Nansen, with all of his skills, nor the League of Nations was able to maintain the supremacy of international law. In 1933, Germany withdrew from the League of Nations, claiming that the League's principles violated its right of sovereignty. And in 1935, 1936, Mussolini dispatched Italian soldiers to Ethiopia, claiming that Ethiopians were not entitled to the protection of human rights law. The other nations in the League, England, France, and so forth, were beset with the Great Depression and other woes, and they refused to enforce sanctions against Germany and Italy. And of course, there were some political sensitivities because Germany and Italy were their one-time allies. And so Europe moved inexorably, inevitably, into another catastrophe marked by grotesque violation of human rights. If there's a silver lining to catastrophe, it's this. We are forced to examine our priorities. And in the dying days of the Second World War, nations again embraced the imperative to subordinate their national self-interest to the rule of law. In 1948, the United Nations adopted the Universal Declaration of Human Rights. The document affirmed many rights that we now take for granted. They affirmed that all humans are born free and equal in dignity and right, and that everyone is entitled to the protections of the many rights articulated in the Declaration without distinction of any kind, including sex, color, race, religious belief, political belief. Gender orientation was not in there. Interestingly, one of the articles provided that everyone has the right to seek and enjoy in other countries asylum from persecution. So it was in 1948 that the right to seek asylum was recognized as a right inherent in personhood, one that cannot be taken away. So in the late 1940s, Europe was still witness to millions upon millions of people who were crisscrossing the continent, having been displaced by World War II and also by the burgeoning Cold War. And concerted action was needed. In late 1949, the UN established the UN High Commissioner for Refugees, and in 1951, they introduced the Convention relating to the status of refugees, which defined the obligation of states with respect to those fearing persecution. The Convention remains our touchstone for Refugee Convention, and this is the definition that we in Canada continue to apply in determining whether someone is in need of protection. This definition is used by all signatories to the Refugee Convention. It's always hard to get a sense of the number of people who've been displaced, and so I've put together some figures that I've taken from the UN High Commissioner for Refugees, UNHCR's Global Appeal. It's a document that comes out kind of a couple of times a year in one form or another. The data always lags a year or two behind because they rely on state parties to submit the figures. So these figures show the UNHCR's estimate of those who were at risk as of January the 1st, 2011, and the total number of those who have been displaced by conflict, only conflict, not natural disaster, is 43.7 million. That was a year and a half ago. So I'm going to ask a question. How many people here know for how many of those 43.7 million Canada has a legal duty of protection? Any guesses? Anyone know? Yeah, okay, but I'm talking about a legal definition, okay? So law tends to be very precise. And the answer is we only have a duty of protection to those refugee seekers, those refugee claimants who actually make it to our border, assert a claim to protection, and meet the definition. Everybody else, out of luck. How many claims were made in Canada in 2011? The answer is upside down. Ooh, can I read it? Roughly 25,000. Okay, so 25,000 people made a refugee claim in Canada. Well, actually, a few more may have made a claim, but they weren't eligible. So that's 25,000 out of 43.7 million. And I make this point to say that the numbers are actually quite manageable. So here we are at a time of massive global displacement, 43.7 million just as a result of conflict. And we find that nations are drawing up their bridges. And this happens over and over again. We've seen it in history when nations lose sight of the lessons of history and give vent to their national self-interest. This is what happens. And that's why we are now contemplating Bill C-31. It's an expression of this trend of the advanced or developed world. I shouldn't use the word advanced. The developed world to thwart the efforts of people to seek and obtain protection in their country. C-31 is designed to make Canada quite an unattractive option for people seeking protection, and it certainly will make it very difficult for anyone, whether or not they have good grounds for protection, to have their claim fully assessed, fully and fairly assessed. C-31 is quite a long act, but even worse, it's complicated. It's got layer upon layer of definition. It modifies this act, which modifies that act, and so it's quite difficult to decipher. And many lawyers and many others have put many, many hours into trying to figure out what the Act says. I think most people have a pretty good handle on it now. I don't have time to go into all the provisions, but I'm going to highlight some of the provisions which are, in my view, of particular concern. So the first is the concept of a designated country of origin. Shana alluded to this. You know, it's the idea that there are some countries that are safe. This isn't new to Bill C-31. It was actually introduced in the Balanced Refugee Reform Act, legislation which the Conservative government introduced in Ottawa about 2.5 years ago. At the time, it was extremely controversial, and many groups worked together to obtain reform or changes to the legislation. And the government had to give in, and they were in a minority position at the time. They made a number of concessions, and eventually the bill was passed unanimously in Parliament. We're coming up on the second anniversary of that bill, the BRA, obtaining royal assent. It will be 2 years on June the 29th that bill received royal assent. And on June 29th, 2012, the BRA will come into force unless the government can get Bill C-31 through first to preempt it. So that is why Bill C-31 is being pushed through in record time. So going back to the designated country of origin, the basic premise is that there are some countries that are democratic, they have an effective judiciary, they generally respect human rights, and are unlikely to produce people who are in need of protection. So as not to clog the refugee system with people from those safe countries, the minister has the authority to designate a country as a DCO, designated country of origin. On designation, claims from those countries would be fast-tracked and unsuccessful claimants removed very, very quickly. So the process for designating a DCO under the BRA was quite different than the process under C-31. Under the BRA, the minister could not designate a country unless certain requirements were met. First, there had to be a minimum number of claims made by citizens from that country, and that number, the minimum number of claims, was to be set out in the regulations. Secondly, the acceptance rate for claims from that country had to fall below a minimum threshold. Again, that threshold was to be specified in the regulations. Once those two criteria had been met, the minister had to consider the human rights record of the country. He had to consult, he or she, we've got a he right now, had to consult with an expert panel which would advise him about human rights in that country and others that were under consideration. Sorry, I'm pulling away from this. I hope people can hear me. So let's look at Bill C-31. Let's contrast the process for designation under C-31. It's the minister, one individual, not the regulations, who could specify the minimum number of claims which would qualify a country for DCO status. And Minister Kenny is proposing 30 claims. So any country which produces 30 or more claims could be designated as a DCO. Secondly, it's the minister, not the regulations, who gets to set the acceptance rate. Minister Kenny proposes an acceptance rate of 25% or less. And in assessing the acceptance rate of when I say acceptance rate of 25% or less, it's actually like a rejection rate of 75% or higher. But the rejection rate doesn't look at how many claims were accepted and how many were rejected. It also includes claims that were withdrawn or abandoned. And so it's quite a misleading figure in terms of determining which countries are safe and should be designated. There are some other criteria, but I'm not going to go into them now just because I'm short on time. But why have I spent so much time talking about this DCO process? Because of its severe consequences. Claimants from a designated country of origin will be subject to extremely fast timelines for their hearing, and that is significantly going to impair their ability to tell their story and to have their claim properly assessed. They will not be allowed to file an appeal, so there will be a single decision maker who gets to assess the risk they face. They will be allowed to file a judicial review in federal court. Now, judicial review is a very technical and fairly limited option, but it does give people access to another decision maker if they're able to navigate the federal court process. However, they won't be protected by an automatic stay of removal. So they may file a judicial review in federal court, but be removed long before the court gets around to assessing the application. Why would our government vest so much power in the hands of one individual, the minister? Well, they say it takes too long to establish criteria through the regulatory process. The minister needs the flexibility to respond quickly whenever there's a rise in claims from a given country. Well, I'm going to leave you to draw your own conclusions about the government's view of the parliamentary process, time-consuming as it is. The second concept is the designated foreign nationals. These are the people to whom Shana alluded earlier, the people who have the temerity to arrive irregularly, that is, with the assistance of a smuggler. Now, not everyone who arrives by boat will necessarily be put into automatic detention, but there's a pretty good chance they will. And the designated foreign national concept applies not only to those who arrive by boat, but it can apply to anybody, a van load of people arriving via the U.S. Initially, the legislation proposed to detain them, mandatory detention for a period of 1 year. That was recently revised. The detention would be for a period of 14 days. They would have a detention review and then would then presumably be remanded back into detention because nobody's going to get out after 14 days in those circumstances. And we'll have a detention review every 6 months. We are looking at massive detention, and detention takes place in correctional facilities in British Columbia. In some cities, 2 cities, Montreal and Toronto, they have facilities which are specifically for immigration detainees. That's not the case here. In addition to the mandatory detention, designated foreign nationals, even if they are recognized as a convention refugee, would not be allowed to apply for permanent residence for 5 years. This delays their ability to be reunited with their families. It delays their ability to integrate fully into our society. They will also not be eligible for travel documents. This is a right that is specified under the Refugee Convention and is one that applies to anybody else who has been recognized as a convention refugee. Why would the government introduce provisions which discriminate against those who arrive in an irregular fashion? Well, they say it's part of their obligations under the anti-smuggling conventions introduced by the United Nations. But in fact, when you stop and read those protocols, and I'm not sure that our minister has, it's very clear that the state parties to the protocols are not permitted to punish migrants who have been smuggled. And in fact, the protocols specifically say that state parties are bound by all obligations under international law, including the Refugee Convention, and they must not subject migrants to cruel, inhuman, or degrading treatment or punishment. We next move into the hearing process, and I know I'm running out of time here. It can be divided into 2. I'm going to leave the right to counsel. The hearing process can be divided into 2 basic stages, the basis of claim and the hearing before the Immigration and Refugee Board. The BOC, the basis of claim, is a document which sets out the basis for an individual's claim. It's quite a complex document. Right now, claimants have 30 days in which to file, or 28 days rather, in which to file a personal information form. That will be reduced to 15 days in the case of most claimants. And claimants who make a claim inland will actually have to present the BOC at the moment that they make a refugee claim. We then move to the Refugee Protection Division, RPD, Refugee Protection Division of the Immigration and Refugee Board. The hearing will take place, again, in extremely compressed timelines. If you are a citizen of a designated country of origin, your hearing will take place within 30 days. If you are another claimant, your hearing will take place within 60 days. Now, I'm going to ask you to think about how DCOs, or anybody, will manage in these timelines. They are going to, on arrival, have to find shelter, food, find the way around the Lower Mainland, complete the mandatory immigration medicals, find out if they qualify for legal aid, obtain, translate, and file identity documents, learn and understand the legal definition of a convention refugee, And let's have no illusions about the complexity of that definition. The Federal Court, Immigration and Refugee Board, and lawyers are grappling with it all the time. Figure out what evidence they need to show that they are at risk of persecution, file, gather, translate the evidence, and the list goes on. This is a charade. There is no meaningful time to present and prepare a refugee claim. It's not a task for the faint of heart, and it's certainly not a task that can be reasonably undertaken by people who are traumatized, lack documents, or have limited literacy skills. We get to the Refugee Appeal Division. I call this Jason and the Golden Fleece, or Jason's Golden Fleece. Jason, our Minister of Immigration's first name is Jason, and the fleece, of course, is this hoax that he's trying to present to us. He is trying to persuade us that this is an appropriate refugee protection system. So an appeal on the merits. This is something that was introduced by the Balanced Refugee Reform Act. We have never had it before. It will remain under C-31, but under extremely tight timelines. The first question is, who gets the appeal? There's a whole list of groups who will not have access to the appeal. Claims by designated foreign nationals. Remember the folks who arrived by boat. Claims by people from designated countries of origin, probably the bulk of refugee claimants. Claims which have been declared abandoned, claims which people have withdrawn, claims which have been vacated, claims which have been cessated. I'm down to 1 minute, so I'm not going to explain these terminologies. In other words, we're going to have a handful of people who are going to have access to the RAD, the Refugee Appeal Division. The second thing is that even if you are one of the fortunate few who gains access to the Refugee Appeal Division, you're going to have 15 days in which to gather all of the documents, prepare a coherent and persuasive argument, and file everything. When I talk about everything, that includes a transcript of the hearing, which can take a couple of weeks to obtain. This is, again, a chimera. It's a mirage. I don't know why they're even bothering, because it's going to cost a lot of money to set this up. I am going to stop there because I think my time is up, and I hope that I haven't used too much technical terminology, and look forward to your questions later. Thank you.
Thank you, Lesley, very much. There have been thousands and thousands of hours of discussion in government and in public about this issue, and most people still don't understand it. You were able in 20 minutes to summarize and analyze it for us, so thank you. Excellent. Now we're going to hear from each of our panelists for about 5 to 7 minutes. Afterwards, I'll facilitate a brief conversation with them and then open it to the floor. Our first panelist is Sherilyn Jordan. Sherilyn has been engaged in support and advocacy for lesbian, gay, bi, trans, and queer migrants since 2000 with LEGIT, L-E-G-I-T, Canadian Immigration for Same-Sex Partners, and since 2004 with Rainbow Refugee. Her doctoral research at UBC focused on the intersections of oppression, stigma, and trauma in the settlement accounts of queer refugees. Her current post as assistant professor in counseling psychology at Simon Fraser allows her to pursue research, teaching, and practice that connect her passion for social justice and mental health. So I'll turn it over to Sherilyn.
Thank you. It feels so good to be in a room that is standing room only for people who care about refugees. This is wonderful. Thank you to organizers and everybody who's here. So, I'm going to start with 2 images that give you a sense of the terrain that lesbian, gay, bi, trans, queer refugees are traversing. The first uses proportion to show the distribution of the world's 43.7 million displaced persons. As countries in the global south sustain 80% of those displaced, Western countries are using increasingly stringent measures to prevent potential asylum seekers from reaching our shores. In her book, Making People Illegal, Catherine Deverne argues that these restrictions and the ways that they punish potential refugees is making asylum itself illegal. Bill C-31 intensifies this erosion of the right to seek asylum. The second, produced by Ilga, gives a sense of the landscape of homophobic and transphobic persecution. Currently, no less than 76 countries criminalize same-sex sexual activity or gender-variant behavior. 5 maintain the death penalty. The vast majority of these laws are the legacy of colonialism. And as you'll hear in this presentation, these laws and legal statutes tell only part of the picture. Refugees who've made claims based on persecution of their sexual orientation or gender identity have lived in defiance of social erasure, stigma, and threatened or actual violence in their home countries. In migrating to Canada, they've engaged with immigration and border systems that screen out enabling or restricting mobility based on priorities of global capitalism, neocolonialism, and post-9/11 notions of security. Undertaking an asylum application entails accessing and working within a refugee system that was not designed with lesbian, gay, bi, trans, or queer refugees in mind, requiring claimants to prove an often hidden and stigmatized identity and to disclose experiences that are often traumatizing and deeply private. Today, I'll be highlighting ways that Bill C-31 undermines the right to protection for queer refugees, sharing examples from our Rainbow Refugee members that have been anonymized and with consent. Queer refugees have fled countries where they've been under surveillance, arrested, imprisoned, extorted, and for some, tortured because of their sexuality or gender identity. Adil, from an East African country that criminalizes homosexuality. I can pull back? Sorry, getting used to the tech stuff here. There we go. Adil, from an East African country that criminalizes homosexuality, moved to the capital city, where he met friends at a gay pub known by word of mouth. A vigilante group started harassing this group of friends, stalking and then assaulting them. Adil survived one brutal assault. When one of his friends was stabbed to death, he went into hiding. Homophobic and transphobic persecution typically occur out of the public eye. People face threats and violence in their everyday lives, within their neighborhoods, faith communities, and families. In relative isolation, stigmatization as evil, deviant, or mentally ill further isolate people. Sexualized violence is used to shame and silence people. For queer refugees, survival has typically required staying vigilant and conforming to avoid attention. Some queer refugees leave in imminent danger, others out of a growing sense that a livable life is impossible. Many do not know that they can seek refugee protection or that the risks that they face constitute persecution. Sexual orientation and gender identity are not named in the Geneva Convention. Queer migrants often don't recognize themselves in images of refugees as mass movements of people fleeing war. Seeking refugee protection in neighboring countries is obscured and often unviable. If Adil had fled to Kenya, a neighboring country, he would have faced 8 to 18 years for waiting for resettlement, trying to survive as a migrant in a country that criminalizes homosexuality with a 10-year prison sentence. Would he feel safe going to the UNHCR? Should he? The UNHCR has much to do to address the homophobia and transphobia within their own organization. Still in hiding, Adil was connected with an agent who agreed to take him to Europe. Instead, he arrived in South America, where he was forced to work as a farm laborer. Over several months, his work crew moved north, and eventually he was dropped off just over the Canadian border. Where people make a refugee claim or how they arrive says nothing about whether their fears are genuine. Bill C-31 punishes refugees designated irregular by detaining them, denying due process, and delaying access to permanent status in the mistaken belief that these measures deter smuggling. If an asylum seeker manages to reach Canada, one of the first questions they face from an anonymous official is, on what grounds? Usually in a fairly public waiting room. Adil went through his eligibility interview and several meetings with his lawyer before he was able to speak about the real reason he was afraid to go back. How would you begin to talk with a relative stranger about being sexually assaulted by police at gunpoint, or having your father lock you up, beaten, and threaten to stone you because you won't agree to an arranged marriage? Under these circumstances, How would you collect documents to prove your fear of persecution? And could you do so in 30 days? Or 20 days if you're from a DCO? Could you do so if using email or fax would put you or your family at further risk? The head of Canada's Refugee Board has publicly stated that LGBT claims are some of the most challenging that they face. Because documentary evidence is sparse, a great deal of weight rests on testimony. Sitting in on hearings for 8 years, I have seen a huge range in approach of adjudicators, some excellent, very fair and sensitive, others highly problematic. Some apply ethnocentric understandings of lesbian, gay, bi, or trans identity. For example, finding it implausible that a queer refugee from Iran wouldn't recognize a rainbow flag. Some fail to recognize the impacts of trauma. Even good adjudicators make wrong decisions when evidence is lacking and claimants unprepared. Bill C-31 creates impossibly short timelines and denies access to an appeal for anyone, for a whole range of people Lesley described. This designated safe country list is profoundly unsafe for queer refugee claimants. A list cannot accommodate the current complexity and flux in protection and persecution for LGBTQ people. For example, the Ukraine has an elected parliament, an independent judiciary, and civil society organizations. Based on Bill C-31, it could be designated. And yet this week, its parliament is considering a law banning speech or writing that promotes homosexuality, and neo-Nazis are attacking LGBTQ people in the streets of Kiev. South Africa recognizes same-sex marriage, yet there are 10 cases a week there where lesbians have been targeted for corrective rape, and police have done nothing to investigate. I know a lesbian and 2 trans women from Mexico, recently recognized as convention refugees, at a time when only 8% of claimants from Mexico are accepted because it is purportedly safe. Their hearings were extremely long, over 8 hours in one case, because of the complexity of determining viability of state protection. It's precisely when country conditions appear safe on paper that LGBTQ decisions are the toughest, and the safety net of an appeal is most critical. A life or death decision should never rest in one person's hands. Real quick one. The federal government is in the process of the most significant reworking of the inland refugee determinations since IRPA in 2002. I remember the lead up to IRPA when I was working with Legit for the recognition of same-sex partners, and the contrast in process is striking. There was 2 years of consultation. We were asked for our input. Bill C-11 was pushed through in 5 months, and Bill C-31 will be pushed through before June. It's a very complex piece of legislation. So it's something that we all need to work hard to understand, work against, and make sure that our MPs know that we're unhappy with it. Thank you.
Thank you, Sherilyn. Our next speaker is Elizabeth Tyee. She's a Canadian-born Roma. Her grandparents came to Canada from Hungary to seek refuge during the Revolution in 1956. She's worked since 2006 at the University of British Columbia, Faculty of Law, First Nations Legal Clinic, as a senior legal assistant, and has received staff recognition awards for her outstanding work and contributions to the clinic and the UBC Faculty of Law. She also gained considerable experience assisting clients as they first approached the legal clinic with a variety of legal issues. She has aspirations of attending the University of British Columbia as a law student and would like to pursue a career in law in the future. I welcome Elizabeth Tyee.
Good evening, everyone. I am here to discuss the effects of Bill C-31 on the Roma community. During my work, there we go. So during my work with the University of British Columbia Faculty of Law, First Nations Legal Clinic, I have worked with Aboriginal people, and throughout my time there, I have seen a lot of similarities between the issues that the Indigenous population face here in Canada and the issues that Roma face in Europe, such as discrimination, forced assimilation, and overrepresentation in correctional facilities. I'd like to start off and say that there is not a large Roma population here in Vancouver, but there is one in Ontario, specifically Toronto and Hamilton areas. And so I'm glad to be here to be able to represent my community and discuss the matter on hand. So just to give a little bit of information on Roma in Europe, there are approximately 8 to 10 million Roma in Europe. They've been there for centuries, and since their time there in Europe, they have faced racism, discrimination, forced assimilation, and overrepresentation in jails. Sometimes there are demonstrations that are held against Roma by fellow citizens, and sometimes people are brought in from the outside. These practices take place with either the permission or the acquiescence of the government because of Roma people's ethnicity. And so we wonder, why are Roma fleeing Europe? Well, to start off with, Roma live in really horrible conditions in Europe. They live without running water, homes are made out of tin, and they face forced evictions. There's forced sterilization of Roma women that's actually been practiced up into the mid-2000s, and the children are actually forced into substandard segregated schools and are treated as having learning disabilities. There's tons of violence against Roma, such as assaults, riots, and arson attacks. There was 58 murders against Roma by non-Roma that took place in the countryside in Hungary between 2008 and 2010. There's been lots of attacks on Roma villages and destruction of property. The police don't do much about it because they're racially biased, and there's a prohibition of Rom from standing for elections. The European Roma Rights Center made a statement on February 16th, 2012, stating ongoing violence against Roma. On average, 1 in 5 Roma are victims of racially motivated personal crime, and 81% of Roma indicated they were victims of assault, threat, or serious harassment. And like I said, very little is done about these crimes against Roma, and even fewer are arrested, charged, and are convicted for the crimes that they do against Roma. So we wonder, why are they coming to Canada? Well, they leave their countries, some for the first time, their familiar environments, family, friends, and loved ones, to come here to try to escape the torment, persecution, and racism that they face in Europe. They come here seeking protection, freedom and liberties, security, stability, opportunities, acceptance, hopes, and promise. But the only welcome that they will receive when they arrive under Bill C-31 is one that they already face in Europe. Canada wants to keep them out, send them back, go back to your country, they are told. So there is a creation by the immigration minister of good versus bogus refugees, and his language is scary, with labeling of bogus refugees from Europe. This labeling of Roma as bogus refugees in the media set the stage for negative ideas about the Roma. The deck is stacked against them from the beginning, and it's hard not to think that many of these policies and rhetoric are not specifically targeting Roma communities or Roma people themselves. Put simply, it's creating racist labels. And as someone who works closely with the Indigenous population here in Canada, I can, on a personal and professional level, say that Canada, unfortunately, has seen this all before. Here is some information on the Roma migration to Canada by a PhD student, Juliana Baudouin, from the Department of Anthropology at the University of Western Ontario. I have provided this as a handout at the back table along with some other information if you're interested. and my sister, Gina Chani-Roba, executive director, of the Toronto Roma Community Centre, the only one of its kind in Canada, states that with the current Bill C-31, Roma refugees will be provided with a removal order 45 days after entering the country if they had unsuccessful claims. This new amendment will now require a 3-year wait for any hope for an opportunity of an appeal on a negative decision. By fast-tracking their claims, asylum seekers will be unable to provide a sufficient case for being victims of persecution, a condition which must be demonstrated in order to receive refugee status under Canadian law. To demonstrate persecution, claimants must find a lawyer, build a case, and in many cases substantiate their claims with documents from their country of origin. It should be no surprise that these documents take time to retrieve, and as the other panelists have said. Put simply, the time restrictions are unrealistic and will only lead to an increased number of failed cases. My conclusion to this, and so what is happening as an outcome of Bill C-31, is that families will be separated and there will be unfair due process with such little time to build a case and provide all the necessary documents and evidence. There's biases based on media and stereotyping that are creating a negative image of the Roma. And designated countries that are being told that are being basically said that they're safe are not safe for Roma. What we can do and what actions we can take, well, we can petition, we can share knowledge, demystify who Roma are, assist where and when we can as service providers, and inform the public, which is what we're doing tonight. We need to demystify who Roma are. Roma are not those portrayed in fairy tales, fables, or legends. They are real people suffering real discrimination with real consequences. And one of the most frightening things about this bill is that it is threatening to treat Romani refugees en masse, once again based on their ethnicity. This is exactly the kind of blanket treatment they are attempting to flee from. Part of the reason why Roma are coming to Canada is precisely so that they will be recognized and treated as individuals and individual people and not having to defend themselves against the mythical gypsy. Thank you for your time.
Thank you, Elizabeth. Our next speaker is Lobat Sadr Hashemi. Did I get that right? She's been working with refugees for more than a decade. Since finishing law school, Lobat has been practicing primarily focused on refugee and immigration law, concentrating on representing highly vulnerable clients, including women who've experienced violence. And she'll be speaking about the plight of women under Bill C-31.
Thank you. I've been asked to focus my remarks on the impact of Bill C-31 on gender-based refugee claims. But before I specifically address that issue, I wanted to provide some context about the punitive nature of this bill. I've had the honor of working with refugees on a daily basis, and I spend many hours with refugees assisting them in preparing their cases. And there's no doubt in my mind that this legislation, Bill C-31, and the changes to the interim federal health program for refugees introduced in the budget bill are an attack on refugees, some of the most vulnerable people in our community. Bill C-31, as other speakers have taken you through, is an expansive piece of legislation, and it impacts so many aspects of our refugee and immigration system, many of which we can't even foresee because we've been given such little time to review and provide comment on it. And I say it's an attack on the most vulnerable because there are so many aspects of it that are simply punitive, that serve no goal. Despite government rhetoric, this isn't about determining who is bogus and who is an actual refugee. Instead, it appears that it's about letting the refugee know that you're not wanted here, we don't care what you've gone through, and how dare you come here and ask for our help. For example, if you look at the provisions for designated foreign nationals that Lesley talked about, and it's a very broad definition. It scarily can include a lot of different people that come here who are determined to be irregular arrivals. But let's take the Tamils who arrived in BC on the Ocean Lady and the Sunsea boats, because we can assume that these men, women, and children will be so designated, as the minister has actually put in provisions that will make these provisions retroactively apply to them, because they apply for March 2009, which is before the date of both of the arrival of those boats. So if it's not about punishment, then why, in the case of these people, why is it that even after they're determined to be refugees, so the refugee board has said, yes, you are a refugee, you're legitimate, you came here, you were scared, we find you to be a refugee, but even after that, you can't get permanent residence for 5 years, which means you can't reunite with your family. That's punishment. You can't get a travel document. That's punishment. There's no other purpose for doing that. The healthcare program changes are punitive. They create two classes of refugees, those who are from designated country of origin, so the countries the minister is deemed by his own criteria safe, and to all other claimants. So before anyone's determined whether or not your claim is valid or not, just right from the beginning, you coming here as someone from a so-called safe country get very limited health care. They say only in urgent cases, and even in their own examples, they're not defining, for example, a heart attack as an urgent case. So this is about punishment. It's not about determining who's bogus and who's a real refugee. Now, in terms of how this impacts gender-based claims, well, it makes it much worse. Many of my comments are similar to that of Sherilyn with the LGBTQ claims. There's many different types of gender persecution claims. The majority that I work on tend to involve women who are escaping domestic violence, years of abuse from a partner, and have not been able to get protection from their home country. So the police in their country have either ignored their complaints, or they haven't even bothered going to the police because they know that the police don't do anything in their situation. And Canada has been recognized as a leader on gender-based asylum claims, being the first country in 1993 to issue guidelines on the special circumstances women refugee claimants face. And with Bill C-31, we're moving backwards. We're making it much more difficult for these women to present their claims. As a refugee lawyer, my job is to make arguments based on the facts of my client's case and the law, and argue how they fit within the refugee definition. And so a critical part of that work, and the most challenging, is ensuring that the client is able to fully present the facts of their claim to a decision maker. And it's even under our current system, it's very difficult for claimants and women who've experienced violence to go through the hearing process and present the facts of their claim, facts that they haven't disclosed to anyone for years. Now they have to disclose it to a stranger deciding their claim. They have to provide collaborative documents, to have the courage to be interrogated about very private aspects of your life in a hearing room. And no justice can be done if a decision maker can't understand a person's claim. And what Bill C-31 does is it puts even more blocks to being able for that decision maker to get where the claimant is coming from. I was going to take you through an example, but I don't have time. Basically, we can only come to the conclusion that it's not about finding out whether or not the person needs Canada's protection. Otherwise, why would we make it so much harder to make that determination? There can be really no illusion. Our government isn't interested in finding out the answer to that question. And Bill C-31 is going to pass. So we need to think about what we can do in any case. And I agree with the suggestions of the other speakers. I really think that people need to hear the stories of refugees to understand that these aren't terrorists, they're not criminals or liars taking advantage of our system, and that we need to see refugees as part of our community. Thank you.
Thank you, Loban. I'm pleased to welcome our final speaker, Harsha Walia. She's a co-founder of No One is Illegal, and over the past decade has been focused on migrant justice issues at the grassroots level, including legal advocacy, community mobilizing, popular education, and direct action. She's also a board member of the South Asian Network for Secularism and Democracy, and was named one of the most influential South Asians in BC by the Vancouver Sun. Her writings have appeared in academic journals, book anthologies, magazines, newspapers, and she's a graduate of UBC Law.
Thank you. I'm also inspired by the number of people who are here in support of refugees and refugee rights. And I know we've been sitting for an hour, so I'm going to try to pick up a little bit of energy. When I say refugee, I'm going to ask everyone to say rights. Does that work? Okay, let's try it. Refugee. Rights. Refugee. Rights. Refugee. Rights. When I say no, I'm going to ask you to say C-31. No. C-31. No. C-31. No. C-31. Okay. As you can see, despite my legal background, I come from an activist background more so. So thank you again for being here, and thank you to the speakers, and thank you for organizing. Thank you so much. I want to start by acknowledging that we're here on unceded Coast Salish territories, the land of the Musqueam, Tsleil-Waututh, and Squamish people. And particularly right now, I don't know if people are aware, but there's a struggle that the Musqueam people have been engaged in to protect their burial sites. I want to affirm my solidarity with the Musqueam people. And stand alongside Musqueam sovereignty rather than the Canadian state sovereignty. So, just want to say that. And that's particularly important, as other speakers have highlighted the struggles of Indigenous people, particularly for those of us who are immigrants, those of us who are refugees, is not something that's merely symbolic. So, the forces of colonialism, the forces that create patterns of displacement all around the world are very, very similar. For Indigenous people who are displaced from their lands here within so-called Canada, within these colonial borders, as it is for Indigenous peoples all across the world. A few blocks from here is the downtown east side, which is a community where many Indigenous people consider themselves internally displaced people. And so affirming our support for that as people who stand in support of refugee and migrant justice is critically important. So I want to talk a little bit about C-31. So for starters, I'm going to call it the Refugee Exclusion Act, and I'm going to encourage other people to also call it the Refugee Exclusion Act, because that is essentially what it does. And when we start to use statistics or names for bills like C-31, it really creates a bureaucratic sense and really minimizes the human impact. So, the Refugee Exclusion Act has massive impacts, and people have already heard about what the bill is, so I'm not going to talk a lot about what the bill is, but I'm going to focus a bit on the impact. And it's important to talk about the Refugee Exclusion Act as coming from a government who has made number of symbolic apologies most recently, right? So there's been an apology for the Kamagata Maru, there's been an apology for the Chinese head tax, there's been an apology for the residential schools. So Bill C-31 and the Refugee Exclusion Act is happening at a time when the government wants us to believe that it is actually not going to engage in these kinds of policies, but is doing the exact same thing, which makes these kinds of apologies quite meaningless, really. And so I've been asked to focus on particularly the South Asian and the Latino communities, because after the Roma community, these are communities that will be highly impacted. I have 3 minutes left, I just started. Okay, I'm going to run through this. I'm going to be fast. And so particularly when we're talking about the designated countries of origin, this impacts these communities in particular. So the designated countries of origin, to simplify it, is basically countries that are going to be deemed safe. So these are countries where Jason Kenney and the minister believes that no refugees can actually legitimately come from. These are safe countries. These are bogus refugees, etc. So this is, ultimately this idea of designating safe countries is discriminatory in two-tier, right? You're deciding that an entire country will not produce refugees. And within that, India and Mexico have been repeatedly named. So again, we don't really know what the designated countries will be, but in the media, Jason Kenney and Vic Taves have frequently mentioned India and Mexico as so-called safe countries and bogus refugee-producing countries. So I just want to tell you a little bit. So the rates of acceptance in India during the years 2009 to 2011 hovered between about 22 to 34%. And for Mexico, between the same time period, 2009 to 2011, the acceptance rate hovered between 13 to 22%. So, countries with relatively, quote unquote, low acceptance rates. In Mexico, for the Mexican acceptance rates, this also, at the same time, we saw a drastic increase in the number of refugee claims, because in 2009, Canada implemented restrictions on Mexican visas, right? So the number of claims actually increased drastically from approximately 2,000 claims to over 6,000 claims last year for Mexico. So the problem with this logic is that it's circular. So we're led to believe that certain countries are safe because they have such low acceptance rates, whereas in fact it's a circular logic because the fact that there are low acceptance rates is actually because of structural flaws in the system, not because there aren't refugees from these countries. And so I don't have time to go into every single flaw within the system, but you can see the very fact that Jason Kenney is even calling these countries as non-refugee producing has an impact on what we believe about the legitimacy of these refugees. Just as a quick fact, the number of deportations in Canada has increased by 56% over the past decade. So that gives you just a little bit of insight into the fact that the increasing number of rejection rates is actually a reflection not of the legitimacy of refugee claims, but really about structural flaws within the system. And the fact that there are fewer and fewer refugees being accepted in Canada. That's a statistical reality in terms of the increasing number of deportations and also how much harder it is becoming for refugees to come to Canada. The second thing that I want to talk about real quickly is designated foreign nationals and irregular arrivals. So it's already been touched on, but particularly irregular arrivals will impact those who arrive irregularly. We've seen that most recently with the Ocean Lady and the MV Sunsea in terms of refugees who have deemed to be smuggled. And so smuggling and the idea of smuggling has been wrapped into this discourse of organized crime. There's been a number of high-profile arrests of those who have been involved in smuggling operations around the MV Sunsea in particular. And we have to really break down smuggling, right? So oftentimes we conflate smuggling with trafficking, for example. Trafficking implies exploitation or some level of coercion, even though, there's some contention around that. But really, there isn't a lot of contention around smuggling. So groups like CCR, the Canadian Council of Refugees, even the United Nations, have at various levels recognized that smuggling can be life-saving. In the face of the fact that there are increasing border controls, more and more people rely on irregular ways to arrive, right? That seems logical. If it's going to be increasingly hard to come regularly, particularly as a refugee who's not going to have documentation, who's fleeing persecution, who's trying to get out, you're going to come in whatever way as possible. And the thing that I find most insidious about the logic of smuggling is that there's a presumption of something insidious about it. When in fact 492 people are coming on a boat, there's nothing insidious about it. They're very publicly declaring their need for safety, right? And so, it's already been touched on what the impact of irregular arrivals will be. I swear to God, I'm going to be 30 more seconds. But so irregular arrivals, in particular mandatory detention, is what is most troubling, right? So the criminalization. And I think, the way that I think about smuggling, it's a little bit like the logic that's being used to occupy Afghanistan. So smuggling is used in particular to say that we're going to protect women and children from the smugglers, when in fact what it's doing is oppressing and punishing women and children. And that's very much like the occupation of Afghanistan and other kinds of colonial imperial logics used to justify the oppression of women. And that we saw that with the MV Sunsea. A number of women and children were detained for months. One woman almost gave birth in jail, and we have to be sure that this is jail. Jason Kenney likes to call detention housing. It's not. It's jail. It's incarceration. And that's what's happening, right? And so that's also has a huge impact on these communities. And so we can see that refugees coming from Mexico and refugees coming from countries like India and Sri Lanka, who currently have high rates, particularly of arrivals on the West Coast, will be hugely impacted by C-31. What I want to say in the last 20 seconds is that C-31, I just want to encourage people to think of C-31 not as an aberration of law, but really something that entrenches structural injustice. So it's really easy to think of C-31 as an exception in what we otherwise see as this kind of perfect refugee system in Canada. And really, that's not the case, right? What we're seeing in Canada is that there's a decreasing number of refugee claimants, there's a decreasing number of permanent residents, and what we have instead is an increasing number of temporary migrant workers who have little to no rights in Canada. And so really C-31 is part of a much broader pattern of illegalization and criminalization of migration. And so really that we should think about that in that framework, and what are we going to do around ensuring that the rights of migrants are ensured across all kinds of so-called categories that they fall in. Thank you.
Thank you, Harsha. I know Shayna had scheduled you last because she thought your energy would have the right kind of message for closing, and I think you did that. Thank you. Let me just reflect very briefly on some of the things that were presented here, and then we'll pass it over to you. Just in the interest of full disclosure, I'm an American. I'm not a Canadian, although I am a Canadian immigrant. I'm not a refugee, but I am an immigrant. I'm approaching this through American eyes, but I think seeing a lot of the same things that you're seeing. As Shayna mentioned, my parents fled communist Hungary, and they were welcomed with open arms in the United States, of course, because of the political reasons to welcome people from Hungary at the time. And I always had this sort of idealistic image of America as this, and it's part of the image that America, of course, puts forward, and Canada puts forward, of, we welcome refugees. We're countries of refugees. We're built by refugees. Of course, there's a whole First Nations, Native American history that's often ignored in that, but that's another issue. And my eyes were really opened when I was a kid growing up in Miami, because I would see in the 70s and the early 80s Cuban refugees coming over and talk about what's the term designated?
Foreign national.
Boat people. They literally were coming over in balseros and in like not even rafts, just like pieces of foam sometimes. And they were welcomed with open arms because, of course, they were fleeing a communist country. At the same time, Haitians were coming over, and they were sent right back to Haiti. And I remember thinking at the time, as a kid, thinking, that's weird. Why? I mean, there are two islands not that far away. What's going on here? Years later, as a journalist, I went to Haiti, and I met some of the people who had machete scars on their skulls because they were hacked by the Tantan Makut. And some of them fled to Miami and were sent back to that persecution. And so this really kind of resonates for me, of things I've seen as a journalist, and things that have sort of moved me as a child of refugees. So there's so many issues, and I'm sure you have many questions. One thing that seems to, a question that I was asking myself as many of you were speaking, was is there any underlying political motivation? I think it was Harsha who mentioned, or I can't remember actually who mentioned India and Mexico as two countries that are deemed safe. Well, I know people in Mexico who have been, horrific victims of the drug war and have tried to flee to the United States and to Canada because of, as refugees, as much as anyone fleeing from anywhere in the world. As I demonstrated in my little story, Cubans were welcomed because of the Cold War. Haitians were not welcome because there was no good political reason to justify welcoming them. Is there anything underlying here in terms of Canadian geopolitical relations that maybe feeding into this? I'll sort of turn it to any of you. Yeah, any of you.
I think it's important to put this in the context of Canada is a trade partner with Mexico, and it does not look good to accuse your trade partners of not protecting rights. What we've seen at Rainbow Refugee is, particularly since 2005, 2005, there's been a sharp increase in political violence, gang-related violence, and the people are arriving with severe state-inflicted violence or gang-inflicted violence that's not being recognized in the refugee system.
I would agree. That was actually the part of my talk I didn't get to. But very much along those lines, I think that countries that have been deemed safe, Mexico and India are clearest examples of that, are countries that Canada currently has bilateral or multilateral trade relationships with. We're trying to enter into them. As we know, India is currently one of Canada's largest trading partners. This space actually hosts the India Summer Festival. And so it's very much tied into that. In Mexico, as we know, Canada has been in NAFTA with Mexico. The SPP, the Security and Prosperity Partnership Agreement, was negotiated with Mexico, the U.S., and Canada. We very much know that NAFTA has had a disastrous impact in terms of displacement and migration of Mexican farmers, for example. And so Canada is, it's interesting because we have to look at Canada as both complicit in terms of the displacement in the countries that it has a trade relationship with, and then simultaneously fortifies its borders against those very people that it's displacing. And so, to me, that's the connection. A lot of the people who are fleeing displacement and migration, there's some level of complicity of Canada and us and other Western countries in those forces, right? If you look at Palestine, one of the largest refugee populations, Canada is directly implicated in a military relationship with Israel, for example. And so there's definitely a connection between foreign policy and immigration policy. And I think one of the biggest the challenges that we have is to have people understand that immigration policy is not just a domestic issue. It's very much connected to the patterns of global empire and capitalism that Sherilyn mentioned, right? So, very much so.
Great. Thanks. Well, we'll turn the questions over to you. Actually, we're going to give the first question. Are people going to come up for questions? Or very good. Very organized. First question actually goes to Jose Figueroa. Okay, Jose Figueroa. I'll let him introduce himself, and you can direct your question to whomever you like.
Well, yeah. Is it on? Yeah. Oh, it is on. Okay. First of all, I think I am not constrained with the time over here, I guess. But first of all, my name is Jose Figueroa. We have been living in Canada for over 15 years now. In 2010, May 2010, I was given a deportation order from immigration. We have 3 Canadian-born children. My son, he was diagnosed with autism in 2002. So the story in these terms is that the rights of my family are being violated by Canada. My kids are Canadians, and they have rights here in Canada. As a parent, I have the right to stand for their rights and to look for the community to support in order to stand for their rights. My daughter, she wanted to come here because she wanted to learn how to defend her own rights. And that's why she's here right now. In terms of the time, Bill C-31, I think that is giving us a little bit of a hard time. It's putting our family a time limit into how we can stand for the rights of this family. So we need to do something before that happens. The Canadian government has up to June 29th in order to pass this bill, and we have up to that time in order to make it stop. So my question will be maybe for Lesley. Right now we are waiting for a decision from the Minister of Public Safety in the situation, in our particular situation. It has taken them 15 years, so that makes 365 times more time that a refugee will have in order to protect their own rights. So what are the considerations on those? We know that statistically he could take 7 to 9 years to decide on a ministerial relief application. we are still waiting for that. Is there any considerations on those aspects for the Minister of Public Safety? And the other thing will be the Minister of Public Safety versus the Minister of Immigration. We have two standing applications, one that was approved in principle in the year 2004, that's the agency, it was approved, and then after 13 years, the Canadian government came with these bogus allegations of terrorism. In my case, they are saying that I am inadmissible into Canada because I was a supporter of the FMLN, which now is the Salvadorian government. Canada has diplomatic relations with that government, which means the Canadian government is supporting a terrorist organization if that is the allegation. So there's a thing about, it's a matter of logic, and you made something, some point. I think that there are some ideological considerations that they are doing, but I would like you to answer on that question if there is some provisions on this C-31 about the time limit that the minister has in order to respond to that ministerial relief application.
I just looked over to Lobat. Sorry, is this on? I just looked over to Lobat to confirm. No, I don't believe that we can impose time limits on the minister. That's a one-way road. And I think that's another way that the government has is kind of a technique that the government has adopted to disenfranchise and marginalize people who are seeking protection. You are left in limbo for years and years and years. The government has claimed that the former legislation, the BRA and the C-31, have been made necessary because the current system is broken. We had a backlog of close to 60,000 claims about a year ago. I'm not sure. I think we may be down to about 45,000 right now. Huge backlog. Well, it was created when the Conservative Party took power and refused to reappoint members, decision makers, to the Immigration and Refugee Board. So there was a period where the board was operating with very few members, and the number of claims just rose and rose and rose. So, sorry, I don't have an answer for you about when you'll get a decision.
Hello, thank you for your presentation. My name is Jean Dudu Hakizimana, and I lived in Canada for the last 15 years. And I made a claim, refugee claim, in Canada. When we're talking about those process, when you see this picture here, remind me in Vancouver. What I'm going to say, maybe I hope no one will against me what I want to say. People ask me, what is the mistake you ever made in your life? One mistake is to make refugees claimant in Canada. And I share this with many people like me in British Columbia, anywhere else in Canada. You can ask me why. Because when these things happen to you, actually you deny yourself, your humanity. You don't even know who you are. And that particular time, they were what you call hardship assistance for refugees. And it was very hard. If you seek food, land, like very difficult. And you exposed to drug, to sexuality, to anything can happen to you. Most of those people who don't have a strong life, like myself, I made my education here, I have my job, I'm surviving. If I explain what I met those particular 2 years without paper in Vancouver, was the people I see in single rooms in the downtown east side. Is anyone here who live in a single room in downtown east side? No. That is a story. You hear, you never know what that kind of life is. Actually, I love Canadians. Canadians are the people who have a good heart, but the government is a criminal government. They are not connected. The faith to help people is not the government. In other countries in Europe, they have a detention house. I wish if I did go to Belgium or France or Norway, they detain me 6 months, and I know after that I'm going to have a paper and I'm going to have a good life. And people will encourage you, will help you. You will be in a process which will help you. If those detention house, has the faith of the government and have a faith that they will help you, you will be integrated, that is a very good process. But that faith is not there. And those 40 million refugees are dark-skinned people, black people. 20 of them are black people. And Canada is one of the countries is not welcoming black people, especially British Columbia. Mm-hmm. Actually, British Columbia wish if there is no black live here. Mm-hmm. That's my question. I want someone to make a comment about that. And, and that's the really true situation, and that's the true life, and that's people living like that. Doesn't matter. I hope no one is going to against me with that. Thank you so much. But that's the true life.
Thank you. Well, let me let the panel quickly respond to that question. I think I know the answer, but is there a clear racial line to the countries that are considered safe as opposed to unsafe?
I would have to say no. You have Hungary, safe, Mexico, safe, India. I don't have the figures at hand. My sense is that the acceptance rate for claims from African countries tends to be quite high. I was surprised recently. I was looking, I think Nigeria is up around 60%. But the problem is that we make it extremely difficult for anyone from Africa to get here. This government also pays tribute to what they call the good refugees, the people who wait their turn in the camps in Africa or elsewhere and are selected, cherry-picked out of the camps. And most of the camps are in Africa, and people will wait decades in those camps. Many will die before they actually have a chance of being resettled to Canada. We take about 10,000 people from camps every year.
Thanks. There's a question there.
Yeah. Hi. Can you hear me? Yeah. I'm not an immigrant. I'm a student in British Columbia. I come from Colombia. I'm a graphic designer. I'm not related to any law background on human rights, but I come from a country who has large issues in terms of human rights. My experience, which has been completely different from a refugee, has been a strong difficulty accessing the information. And after having made a few processes through becoming a student and then getting an off-site campus, I'm starting looking at this premeditated complication of the access to information. It feels that is a segregation, a cultural segregation in terms of hiding the information, making it complicated. You can feel that things are hidden, put behind other things. You can easily divert. And I think that in the process of a refugee, they will face that kind of challenges. So is there an organization or someone who is auditing those online tools or the forms that people need to fill in order to make, this very short process even more, even better? I don't know if you can speak about that or.
I'm not aware of organizations that are auditing, but there are certainly community organizations that do some of the bridging and mediating work. That's LOBAT's works at one, Versa and Vast SOS are all on the ground. But I think your observation of the ways that sort of access to information obscures access to justice and bars access to justice is really bang on.
My name is Elsa. About 6 years ago, we applied for Refuge. We participate in 5 hearings, 2 judicial review, and now we go again for the new hearing. But my point in this question is suppose the law is the same for everybody, for the government and for us. But we received many mistakes. In the first hearing, we received the letter, you can present any proof, any widow, any nothing, 20 days before the hearing. But 2 days before, 48 hours before, the Minister of the Justice sent the one letter, he will participate in our hearing with the one widow, and then our hearing was 1 day, was 3 days. And the result is the judge said, you can go to your country and you explain everything here, and you have the same justice in your country. I don't know what is the judge. My country, El Salvador, no have a justice the same here, and then he can hear our barrister, our lawyer in our country. He running in this time, and then we go to the judicial review. We won to the hearing 2 times. We won, and now the Minister of the Justice appeared again and said, no, we don't accept the resolution. But 3 days after the time is the 1 month, they apply in the federal court 33 days after the resolution, 3 days after the timeline. And the federal court accept the resolution, and we go to the federal court, and in the federal court we have a crazy judge because it's insane and crazy and make the judge not correspond. What is the justice of the government? It's not one older judge and was not on sense. He come in the salon and say, close the line. I don't want the line. I don't want to talk to nobody. I think we finish now. You go again. He don't hear our lawyer. He don't hear nothing. He made the decision. We have the federal court and finish at 1 p.m. and the next day at 9 p.m. at 9 a.m. we have a resolution 22 pages. It's crazy. We go in at this point with the some resolution. We don't hear nothing about. We apply for study here. You're not a resident. You have to pay like international. You apply for the one job. I am civil engineer. Have 2 master's degree. 1 in Europe. 1 in my country. Nothing is valid.
Let me just interrupt. Can you give us a specific question?
My question is, what is the reason the government made anything out all the time? If we apply for something, the law is our size. For the government, doesn't matter 3 days before, after the time to limit it for the federal court is 2 days, 48 hours before the hearing, where the law say is just only 20 days. You have to present everything. What is the reason the law is only in our size? The time limit is in our side, and for the government made any mistake, and the federal court accepts everything.
So it sounds like one of the issues here, and some of you have raised it, there's obviously the time limit issue, but there's also a sort of an arbitrariness that I think we've heard here, and I've heard from other refugee claimants, that it doesn't seem like there's a sort of a straight sense of due process. Is that something that you've seen in your work? Maybe we can hear from some of the folks who haven't spoken yet.
Yeah, there definitely is a sense of arbitrariness because so much of it is decided by one decision maker. So that makes it definitely feel as if it's arbitrary. No matter all different processes in immigration, usually you're going to one person to make that very big decision. And in terms of the minister being given special leeways, certainly Bill C-31 doesn't make it any better, it makes it much worse. There's actually provisions in it with respect to the appeal, I mean, for those who have access to the appeal, where it's blatantly set out that some rules apply to the minister and some rules apply to claimants. And so, yeah, I agree. It's not fair, and it can feel very arbitrary.
Thanks.
Quick follow-up over here also.
Okay.
Thank you. Oh, I asked for the teacher because she's my wife, and she forget to say something important. The justice, I mean the judge, before the judicial review, called our lawyer. He's one of the colleagues in Elgin of the lawyer. And this justice said, our lawyer, that he speak with the other part, the minister. What is that? What kind of country is this? The judge speaking with the other part and call our lawyer and said, and you know all the lawyer has fear to the judge. So it's natural, that is important. But it's unfair for us.
So are there rules about ex parte communication with these situations? Some of the lawyers here maybe can comment.
Sounds quite unusual to me.
We only have about 20 minutes left, so it's wonderful to hear all of your stories. If we could try, just for the sake of getting as many questions in as possible, if we could try to keep the comments and questions as concise as possible, I think that would. I think everyone would appreciate it.
Hi. Hello. Oh, there we are. So I had a question. I was struck by the last speaker when you said that this was an entrenchment. That sort of struck me a little bit, because I do have kind of maybe a very naive idea about what Canada is and what it represents. But you think about it, Canada wasn't nice at all to Jews coming here in World War II. So can we talk a little bit some of that this is sort of an entrenchment rather than a change or an aberration or a sudden kind of shift in policy? It's sort of a solidifying of some things that are going on in sort of minor ways, like a long bureaucracy, difficulties, and different kind of definitions. Could we speak more to that history and how it's kind of continuous rather than disruptive with it?
Want to take a couple or just one?
Why don't you start?
Thank you for that, and I think, it's what you said. I think we probably have different opinions on this panel and within this room, but I think there's kind of a paradox, right? Because on the one hand, Canada's recognized as this leader in accepting refugees, but when we look at the scale of displacement and some of the kind of facts in terms of who is displaced and where most displaced people go to other countries, right? So when we're talking about Canada accepting a large number of people, it's really minor in the scale of how many people are displaced. But definitely if we look at policy, and we also just look at popular consciousness, right? Part of this is about law, but part of this is also about just how, just hearing people's stories about how people feel as refugees and migrants, question and the comment about race and racism within society. These are deeply entrenched that go much beyond one policy and one law. These are kind of embedded notions of who belongs and who doesn't. And certainly, the St. Louis, the Kamagata Maru, the Chinese head tax, the Japanese internment, there's so many examples of communities constantly being cast as racial outsiders. That often goes beyond someone's legal status, right? And so when we talk about refugee policy, in my opinion, devoid of context of race and devoid of a context of class, then it becomes harder, perhaps, to see this kind of embedded nature. But when we look at it within that framework, it becomes much easier to see how refugee policy, and particularly restrictions on refugees, is really part and parcel of this nation-building exercise, right, about who belongs. And it wasn't very long ago when the idea of white Canada was really popularly talked about. Now we don't talk about white Canada openly, but we have really harmless ways of talking about who belongs and who doesn't, right? So we can often talk to people of color who've been here for generations and ask them where they're from, which to me reveals a kind of innocuous sense of who belongs and who doesn't. And so I'm answering your question in a different way, because what I'm interested in us thinking about is the ways in which race is constructed in popular consciousness and how refugee policy feeds into that and again entrenches that. And so for me, yeah, Bill C-31 is really part and parcel of a much longer legacy of racial exclusion, of racism within Canada, and it's part of a whole bunch of other patterns and policies and legislated exclusions. So that's the short, long answer.
And just sort of to piggyback on that, but to look at some more recent history, I guess. Just a quick, like a comment and a quick question for the panel. It feels like C-31 is kind of a remanifestation of a bunch of other bills that didn't get to pass because the Conservatives weren't a majority then. And now they are a majority, and they've actually put in a lot of incredibly horrendous things in this bill that weren't a part of the bills before. And also a bunch of things that sort of have led up to it. For example, I don't know if anybody really talked about this, but 300,000 applications were virtually wiped out. And these are people who have been waiting and have applied like 10 years ago. 300,000 applications, and we don't hear about these things, and it's not a part of C-31, but it's already happened. So I think the follow-up question for me is like, how do you see Bill C-31 within the broader context of like the Harper government? Because I'm in here in solidarity with the students, but there's obviously in Quebec, but there's obviously a lot of other stuff that the Harper government is doing that's like horrifying, and it's all being pushed through because they're a majority, and I'm just wondering if you can comment on that, anybody really.
All in a nonpartisan way, right?
I'll talk a little bit about my experience of the difference between addressing the Standing Committee on Citizenship and Immigration for C-11 under the minority government situation versus the majority government, conservative majority government situation. There was, in my experience, some attempt at respectful engagement and Parliament working together to create something. There are many ways that C-11 was continued retrenchment of a very regressive refugee policy. Sorry, I got a message. Explain what C-11 is. This was the legislation that was pushed or moved through 2 years ago. Whereas when we are looking at the way that C-31 has been, it has been pushed through, and there was, if you look at those proceedings, no effort to really listen, engage, dialogue at all.
Actually, can I ask a really quick follow-up maybe to Elizabeth? One of the things that's been often brought up is that one thing that's supposedly spurred this is this real concern for the large number of refugee claimants from Hungary. I've been outspoken about my concerns about the Orban government in Hungary, the right-wing government, which has been quite discriminatory and has made in my opinion, made the situation for Roma in Hungary more difficult. But there are a lot of Roma refugee claimants from Hungary. Do you think that has played into helping to push this further along than it might have gone?
Oh, definitely. I do think that is very much the case. It's actually very interesting to know that the minister traveled to Europe to actually hand out pamphlets to the Roma community, trying to get them to not come here. And so he's taking a very proactive role in going to some of the European countries that a lot of the Roma refugees are coming from, such as Hungary, Slovakia, and the Czech Republic. and he's trying to deter them from coming here because of the fact that he feels that a lot of their claims, as he is stating, are bogus. And there was one time where he noted that there was a whole plane of Roma that came over from, I think it was from Hungary, but that he said, basically stating that people are coming here in planefolds trying to claim refugee status that are bogus. Meanwhile, those claimants that arrived that day were basically five families that made up of those 71 people. He also basically he's tried to deter Roma from being even interested in coming to Canada. So it's definitely, I think that part of the problem that he sees as it is a Roma problem is could probably have to do a lot with Bill C-31 and trying to keep Roma refugees out of the country.
And just so everyone knows, we are going to have to, we have our questions. We have lots of questions. So everyone who said that you can speak a question, you have the question, but nobody else at this point can, in this forum, ask a question. However, I am sure that this will not be the end of the conversation. So we do have some questions already selected, and unfortunately we're going to have to cut off the speaker list at this time. So just so folks know.
Hello?
Thank you for the information. It's looking pretty much like a reactionary time we're in here. My sense of it all is that we're being totally railroaded. Totally. In a number of ways, just like the CP rail strike being railroaded through Senate and everything right now. They are putting us off balance. And we're at the end of our time, and my question is, from your position of privileged knowledge and experience, what's the next step for us?
You stole my last question, but that was a good one.
I was going to just try to answer that one and connect it maybe to the previous question, because you're both kind of tying into this broader framework about what's happening. And just to emphasize a few quick points. So, one is, again, the C-31 is happening at a time when other policies being passed. So there was reference to the 300,000 immigration applications being wiped out, many other immigration and refugee policies that are happening. And so I think what we have to do, I think one of the problems in terms of conceiving of C-31 is because there's a conservative majority, it becomes hard to imagine what one can do to stop this legislation. But I think when we think about it in a broader context about social movements, when we think about the kind of popular movements, the kind of popular education we need to create, there was reference to the Quebec student strike, which is incredibly inspiring, right? And I don't, people really trying to create change when it seems impossible, being able to do that. And I think particularly with the Harper government and the connection to C-31, I think there's several, right? So Bill C-31 mandates increasing incarceration. That's happening at the same time as we're seeing prisons being expanded in Canada. So there's a huge connection between criminalization and prison expansion and refugee criminalization. Bill C-31, again, entrenches this kind of racism, and we're seeing this kind of racism in all ways in Canada, right? So we're seeing the niqab ban, we're seeing an attack on Indigenous people, we're seeing an attack on immigrants. So if we understand Bill C-31, then we can see the need to create much deeper anti-racist popular consciousness. I think that's a key strategy. I think the final piece is that Bill C-31 really is connected to austerity, right? We're living in a time where corporations are getting bailed out, we know that. Refugees are a product of these systems. And refugees and immigrants are being criminalized at a time where we want more and more temporary foreign workers. So what Canada wants in an era of austerity is cheap labor, right? So workers are being attacked. There's reference to the CP rail strike. There's a number of strikes going on in Canada. Permanent residents and refugees are really being dissuaded essentially from coming to Canada, because what Canada wants is migrants to represent commodified labor. And I think the answer to that is really to flip that and say, no, we want to welcome migrants as human beings. We want to welcome refugees as refugees who belong to a global humanity. And we won't accept a logic where migrants are just going to be cheap labor and cash cows for capital, right? And so I think when we see these as connected, it gives us a platform to start imagining the reversal of C-31 and this whole entrenchment of anti-refugee policy. And so I think the answer really is in broad-based social movements, is my answer.
Hello, can you guys hear me? Yeah, my name's Caroline. I totally understand where you're coming from, Harsha. I think we may know some people mutually. I don't know. Like I'm from the Philippines, so I totally know everything about like temporary workers, disposable workers. Live-in caregiver program. Hello, right? But anyway, so I've been here for more than 16 years, and I've actually only been here a year longer than Jose Figueroa, and I'm a citizen, and like how I belong to this nation is not questioned. Just because my parents gone through official route, because we had money to shell out for like an entrepreneurial route, whatever, start a small business sort of thing, right? And like I don't really see how my citizenship is so different from Jose, So that's just personally why I'm invested in this case. But then like I totally understand where you're coming from. It's not Bill C-31's not the end all be all. It's just like one. The latest deadline, all that. I understand that the broader strategy is broader social consciousness of how it's all interrelated, right? And instead of just looking at it on a specific policy by policy basis, but specifically, in the next month, what can we do?
Organize.
Organize. Use your anger.
Organize.
What activism or social mobilization looks like is different for everybody depending on what your social location, your social position, your class, your occupation. So figure out where your power is and use it. It is not too late to be letting MPs know that you object to this bill strenuously. It will probably pass because of the majority government, but Liberal and NDP MPs need to know that they have support from voters when it comes to election time to address some of these regressive measures. So write to your MPs, email them, call them, show up at their offices. Talk to your friends. I know June 18th at noon, the CIC office at 1148 Hornby, there's going to be a lot of angry healthcare workers. I'll be there. Wear your scrubs or your lab coat or whatever you use to identify yourself as that part of a healthcare worker, and all are welcome, okay? Show up, noon, CIC office, 1148 Hornby.
The Hornby one.
Okay, wait, check. Okay, my name is Han, an international student from China. I have several questions. The first is, what makes those countries such as India, Mexico be deemed as safe country which produce few refugees? Is just because of few claims, or are there other reasons on the table? The second question is if the bill is passed, is that possible that the bill will actually help the BOGUS instead of real refugees to get acceptance from government? Thank you.
Sorry, what was the first question? I knew I should have written it down.
Mexico and India.
How do we determine the safe?
Elections and trade. Quite simple. Mexico has a democratic process of sorts. I had a client once who had the misfortune to be witness to electoral fraud, which resulted in the election of the previous government, but nonetheless it's perceived as a democratic country, and it's very embarrassing for our Prime Minister to have to say to the President of Mexico that we don't consider you to be democratic. Oh yeah, will this process help bogus claimants get through? I think it will.
You're the lawyer. If you look at what sort of helps good decision making, it's the first person who looks at the evidence, having the best possible evidence. Okay. This process works against that. If you look at what helps good decision making, it's also the claimants being well prepared. This works against that. Okay. And so I think, in fact, in many ways, this process it's a charade. It will lead to poor decisions in both ways and does nothing. And I also want to point out, it's important that we not play into the language of the bogus refugee. Minister Kenny is very proud, or frequently uses the number of 58% to suggest that that's the number of sort of false claims that are there. No, that's the percentage of folks who are refused, but many of those folks have very legitimate fears. It may not necessarily cross the threshold of what is considered persecution by a decision maker, but they're very legitimate fears. And that also includes a number of decisions that are made poorly. So be aware of the language of bogus, and let's work not to repeat it.
Hi, I was just wondering if, I know we've spent a few questions already saying, tell us what to do, and I totally appreciate people are saying, it's a big issue, it's a broad social movement, there's no one simple answer. I was just wondering if there were any, in the last little while, if there were any actions that had inspired any of you that maybe some of us might not know about that you could share as way of inspiration. And also, if you could kind of give, I understand that it's different for everybody in terms of how they want to protest something, but if maybe from your perspectives, if you might have like a top 3 or your top 5, what we can do in the next month. I always think of, is it Rosa Parks, who kind of, she did a really great civil disobedience, and just showed to a lot of people that not all laws are just. And so sometimes people that I think are involved in politics, they just take for granted the real specific things that you can do in your, to protest. But some of us need to kind of have some examples spelled out. So I just thought it would be great if you had any kind of inspiration to share with us.
I just wanted to say that I think it's really important for people to speak out and to contact your governments, write letters, get together and petition, and to let people know that you're not happy with what's going on, especially the government, and to let them know that you will not accept certain things to happen without them knowing your disappointment and that you're not in agreement with it. I don't know if anyone else has
a movement that's inspired me, in Montreal, May 21st, in defiance of Bill C-78, a group of migrants and allies walked masked. It was very inspiring.
I think the government can be more responsive than we realize. The one instance that I can think of where they actually backed off proposed legislation was the proposal for computer surveillance in the interest of combating child pornography. And the public outreach was so strong that they actually stepped back. I think we can take examples from the environmental movement. They are proposing a blackout in early June to protest the government's attempts to silence them in various ways. I do think that there are patterns that are being repeated in different niches of the government's work, and one of those disturbing trends is the concentration of a lot of power in the hands of very few people, and that's something that we have to speak up against. It goes very much against the rule of law.
Just so folks know, we have about 3 more questions and then we will be ending. So if you can just hold off for those last 3 questions, and everyone, I'm sure, will be brief and concise.
Hi, I just have a very quick question. What is the current success rate of legit refugee claims that have been processed in a reasonably good time frame and those people are living happily here in Canada? Are there any good stories at all for refugee claims here? That's my question.
So are you talking about the number of refugee claimants who were accepted at the refugee
That's
board?
right, yeah. They were legit, they were accepted, they were processed in a reasonably well, okay time frame, and those people are happy with the way they are living here.
It's been roughly 40%, give or take a few percent, for a long time. I hesitate a little bit to use the word legit, because we have examples in this room. I'm familiar with Jose's case, I'm not familiar with the others, but there are strong cases which fell through the cracks. And in my experience, the ones that fall through the cracks are often those of people who were traumatized, because traumatized people who are most in need of protection, often have the greatest difficulty articulating their claim. But the overall success rate is about 40%.
Hi, I have a question for Harsha. Seeing as we're here tonight in the Goldcorp Center for the Arts, I'm hoping that a speaker, perhaps Harsha, could shed light on the role of Canadian mining corporations, mining and oil corporations, in devastating the environment at home and abroad and displacing people through this process. Thank you.
4 words, Harsha.
Thank you. I actually was going to mention Goldcorp. So for people who don't know, Goldcorp, Am always corrects me on this. Goldcorp funds the center, am I right, Am?
It's so complicated.
It's he always tries to convolute it. But Goldcorp gives funding to SFU, so I think it's important to recognize that we're here talking about refugee rights, and we're sitting in a space that's complicit in the displacement of particularly Latin American communities, right? So Honduras and Guatemala. So Goldcorp, short, is one of the world's fastest growing gold producers. It's one of Canada's largest mining operations. Its headquarters are in Vancouver. There's a number of legal cases that have actually been filed, particularly by Guatemalans, about Goldcorp's role in displacing communities in Guatemala. And so, yeah, I mean, Vancouver is mining headquarters, and so I think when we talk about refugees, we talk about it in a really narrow frame of persecution, but displacement is increasingly connected to environmental degradation, environmental refugees, displacement due to, massive corporations. So, the tar sands is, again, going back to displacement of Indigenous peoples, is displacing Indigenous peoples off of their land. So I think thank you for that question, because it is important to talk about displacement in much broader frameworks than just, the very narrow confines of the Refugee Convention. And Goldcorp is very much complicit in that, so we see the twisted logic of sitting here very uncomfortably for me.
Hi, my name is Israel. I'm a refugee, and then I really passed through the hard hearing with 3 judges, and I made 2 with a positive. But also I'm concerned, and my question is, when this bill passes, the government will have the right as a refugee to mark us in the system and have less chance at work or schools. So I'm concerned with that, because already, 90% of people that I meet, they ask me, so what is your status? And it's hard for me to say that I'm a refugee, because the government tried to block us like a bad people. And I feel like it's hard to feel no shame, because we know the reality, and also to be strong. Plus, we had to pass through for the racist and classism. So that is my question: is the government will have the right? They mark us in the system, Thank you.
Is that our last question? Okay, great. Well, thank you.
Answer.
What's that? Anyone want to?
Question or comment?
I don't think it was mostly a comment, but I think that as many people and as this last commentator pointed out, this bill seems to be a fait accompli. Nevertheless, we had standing room only here, and I think there's hope. I think it's a real endorsement of the democratic process and of the power of voices to make change. We've seen over and over in Canadian history and U.S. history how things happen, injustices happen, and sometimes they get entrenched for long periods of time. But democracy has a way of self-correcting at some point. And several people ask, "What can you do?" It is. I can see how it'd be frustrating, given that there's a sense that this bill is going to happen one way or another. But the fact that this is going on, these conversations are going on, and you, all of you in here, will keep this conversation going, I think gives a lot of hope. Thank you to the panelists. Thank you to all of you for showing up. Thank you to Am, and especially to Shana for organizing this.
And just so folks know, this was recorded. There will be audio and video available. If you sign up in the back over there, don't worry, nobody but us is going to get the list. You're not marked in that way. We will be able to provide you with the audio and the video, and you are free to use it as you wish in the actions that you wish to take. So, thank you.
Sure, you mentioned the literature at the back as well?